Good morning or good afternoon to wherever you're joining us today. My name is Daniel Johnson, and I'm the Director of Marketing and Customer Experience here at myHRcounsel. I just wanted to say that we really appreciate those of you who are attending today, and especially those who continue to attend webinars each month. Before we get started, I wanted to remind you that this webinar is being recorded. Tomorrow you'll receive a follow-up email that will have the slide deck, the webinar recording, as well as the HRCI or SHRM certification credits. If you have any questions about the materials presented and you are a client of ours, please submit a ticket through our Ask an Attorney portal so that we're able to provide specific legal advice to your question. If you'd like to learn more about our subscriptions, which include unlimited legal advice, as well as an employee handbook that would get you started for 2023 at just $149 per month, please contact us at info@myHRcounsel.com. And now I'd like to welcome today's speaker, Britt Waterman, who is a senior attorney here at myHRcounsel.
Thanks, Dan. Well, welcome to preparing for 2023 state and federal law changes coming in the new year. I am, as Dan said, I am a senior attorney here at myHRcounsel, and I've been advising on all things HR and employment law related for about 5.5 years now. You can look at the next slide. So we're going to talk a lot about state-specific laws that might not apply in the states in which you operate. And that's okay. Most laws are part of a trend. So similar laws could have been made effective in your state in 2021 or 2022, or are currently being tossed around at the legislative level in your state, which is why we're here to make you aware of state laws. Hearing about these new laws and asking, wait, did they pass one of these in my state? Or being on the lookout about what's being proposed by your state legislatures. How is it the same as other state laws? How is it different? What would you like to see? What kind of lobbying efforts can you engage in? Most laws trending right now and become more employee friendly as time goes by. So if you see something that you don't want to come to your state, if you hear something here today that you think, we don't want that, first find out whether it's already in existence in your state and you haven't been compliant, and we will help you to become compliant. If it's not currently a law in your state, you can organize, you can join a trade group, you can voice your concern to your legislators who support small to medium-sized businesses. So you may not see your state today. That doesn't mean that there is nothing on the horizon for your state. It may mean there are no major or large bills being passed or laws going to effect on January 1st, 2023. But it does not mean that you do not have to be aware, that you do not have to be on the lookout, and it does not mean that you do not have to pay attention to states other than the states in which you are operating. So privacy laws are a new thing that is shifting in January of 2023. California's law is kind of the first privacy law. They had the California Consumer Privacy Act, which was the first privacy law that did have a carve-out for employee data. They have now passed the California Privacy Rights Act, which amends the California Consumer Privacy Act, and it takes away that employee carve-out. So California's new law goes into effect January 1st, 2023. Virginia's also got a privacy law going into effect January 1st, 2023. Colorado and Connecticut are going to into effect July 1st, 2023, and Utah is going into effect at the end of 2023 on December 31st. So in all states except California, you are going to have to change the way you deal with consumer data. In California, you are going to have to change the way you deal with consumer and employee data. But in all states except California, you're going to have to change the way you deal with consumer data. This could involve huge training efforts for your employees. Right now, however, applicant and employee data are not included as consumer data in all of the states except California, as I said. So in California right now, taking away that employee carve out, if you are a staffing agency and you had someone apply for a job 4 years ago and you put them in your system and you showed their resume to clients, but they never accepted an assignment and they disappeared off the face of the earth, and they call you 4 years later and say, correct my personal data, you got my phone number wrong. You must correct it in your system, and you must make sure that your clients correct it as well. If your clients kept this person's resume, you have to contact your clients and make sure they contact the or correct this individual's phone number on their resume. So it's very serious as far as keeping employee data correct, and all of employee and applicant data that you do store. Employees and applicants, former employees and former applicants do have the right to ask you to delete their data, to correct their data, and this could be huge amounts of information that is now subject to this. The California Privacy Rights Act also creates a new category of sensitive personal information, which has stricter protection for use and disclosure requirements when collecting. This can include social security number, race, which you collect on the EEO form, biometric info, which you might collect on a time clock. There are new disclosure requirements for collecting that information. For right now, in California, this means an overhaul of how you handle employee and applicant data. Presumably, you're already complying with everything else. It's going to include an overhaul of how you handle consumer data and how you train your employees in Virginia, Colorado, Connecticut, and Utah if your business qualifies under the law. So let's move on to the next slide, pay transparency laws. So California, Washington, and New York City has already hopped on board. These jurisdictions joined Colorado, which already has this law. So four other states already have the on-request requirement. So these jurisdictions will require employers to post a good faith hourly or salary range for all jobs in all job postings. So 4 states, as I said, currently have the on request requirement, which require you to provide the hourly or salary range to job applicants during the application process. Rhode Island starts on January 1st, 2023 at a slightly stricter level, more than on request, but less strict than California, Washington, and New York City, requiring that it's in the job posting. Other states have proposed this at the state legislative level. So it is almost guaranteed that this pay transparency, this requiring employers to post the salary range in all job postings, is coming to one of the jurisdictions where you operate. This is there's a guarantee that this is spreading to other states. So this is for any job that could possibly be done in California, Washington, or New York City, and this has to be posted by any employer who does any business in these locations. You may have to post different salary ranges for remote workers because the minimum salary range is going to vary from state to state, and you may want the job to pay minimum salary. Also, the cost of living may vary in different regions. So if you are trying to reach different remote markets, you may have different job posting ads with different salaries. This is required for California employers with at least 15 employees, Washington at least 15, New York City at least 4 employees, but it doesn't matter where those employees are. And there's also the idea that someone out of state may see the posting and decide to relocate. So of course there are remote workers everywhere who might see a remote position and apply, but if you're posting a dishwasher position in Los Angeles, do you have to post the salary range when, everywhere? Because someone in another state might get forwarded the posting from a friend and decide to relocate to become a dishwasher in Los Angeles if the price is right. We don't know. We don't know if you need to post the salary range when you're looking for remote workers. Colorado does have the requirement that if the job posting may be seen by anyone who may decide to relocate to Colorado or work remotely from Colorado, the job posting has to, or the salary has to be in the job posting. This has led to employers to post no Colorado employees in their job postings to avoid having to post the salary range. It's unclear as to whether employers in California, Washington, and New York City are going to do that, and whether this is something that will have to be done like in Colorado, where any applicant who may see the posting will have to have the salary information posted. As staffing agencies who are just inviting people to join the staffing pool and not recruiting for a specific job, do not have to post a salary range. So if you are in staffing and you're not posting for a specific job, you're just looking for people to join your hiring pool, you do not have to post a salary range. But the shifting trend is from requiring information on request and shifting towards putting it in the job posting, putting it up front. If you're not giving it to people before they apply, you're in violation. So this is what we're expecting to see across the country starting in the coming years. So you can see the next slide on minimum wage increases. As you can see here, I'm not going to read all of them. You can look for your own state. As Dan said, we are sending out the slide deck so you can see whether your state's on there. If you have questions, certainly if you're a client, open a ticket. If you would like to have access to this information and be up to date, you can contact us at info@myHRcounsel.com and be able to open a ticket and ask questions about your minimum wage. A few other states are going up during the year. These here are the January 1st states, the ones that are going up January 1st and doesn't include the ones that are going up July 1st or some other time during the year. Minnesota, you can see large employers and small employers have different rates. The differentiation is based on gross revenue. New Jersey doesn't mean what New Jersey has a different differentiation for seasonal employers. This doesn't mean if you have one or more seasonal employee, you can pay all of your workers at the lower rate, even if they work year round. It means that's the minimum you can pay the seasonal employees. So just because your business has some seasonal employees, that doesn't mean you can pay everybody at this minimum wage. That's for the seasonal workers only. So moving on to tax bracket changes. The IRS has raised the upper limit on all tax brackets, which means they're taxing more employee earnings at a lower rate. So employees are going to see more take-home pay starting January 1st. So employees, when this changes, may be withholding too much or too little. Some employees should be withholding more or making estimated tax payments to avoid a big bill, although the majority of employees do over withhold, which leaves them with less take-home pay to pay the bills. Things that employees may want to change now that the upper limit on all tax brackets has been raised. How much to defer into a 401k or an HSA, whether to participate in a non-qualified deferred income plan, additional paycheck withholding amounts, and as I said, quarterly estimated tax payments. So now that the tax bracket limits have been raised, your employees may want to change these 4 things in response to the tax bracket changes. So be on the lookout for employees who may have questions about these things, and be prepared to answer these questions and to assist these employees. Always encourage employees to use the IRS tax withholding estimator. Anybody can use the withholding estimator. It's very easy to find online, and it's very user-friendly. I think we all know that you cannot help an employee fill out their W-4 even a little bit, but there is nothing wrong with sending the link to the withholding estimator to your employees and letting them know that the IRS has made tax changes as of January 1st, 2023, and that now is a great time to see whether they are withholding too little, enough, too much, and to let them know that they can complete a new W-4 at any time of the year by coming to payroll or HR or management. Make sure you do not make this sound mandatory in any way. You want this to be kind of a hot tip only. There have been changes by the IRS. Look at your 401k and HSA. If you want to, use the estimator if you want to. There's no reward for doing any of this. There's no punishment for not doing any of this. This is just some new info. And like I said, you can't fill out an employee's W-4. You can't tell them to change their withholding or to put more into their HSA, but giving them a heads up that the upper limit on tax brackets have been changed, and that the withholding estimator does exist out there, and that if they did want to change their W-4, you would be happy to take one. I think you can figure out a way to finesse it without crossing the line, and that's what you want to do to make sure that employees are not over withholding or under withholding, and either not having enough take-home pay or getting a big tax bill at the end of the year. So moving on to bereavement leave. California has amended the CFRA to provide 5 days of bereavement leave for the death of a family member. That leave can be unpaid, but the employee can use PTO, vacation, or sick leave for that death of the family member. Now that's the leave can be unpaid, but that's job protected leave. You cannot deny those 5 days of bereavement leave for the employee, and you cannot count them as an unexcused absence or penalize the employee for taking those days in any way. So it's part of the California Family Rights Act, which is similar to the Family Medical Leave Act, the FMLA. If the employee has a qualifying death of the family member, you are required to provide those 5 days. There's no undue hardship exception. You have no choice but to provide those 5 days. Illinois has amended their Child Bereavement Act to the Family Bereavement Leave Act, which provides 10 days unpaid leave for the death of a covered family member, and also allows 10 days unpaid leave for any loss related to pregnancy or adoption. The 5 days in California are separate from the 12 weeks. Under CFRA, you have to be employed at least 30 days to take those 5 days of bereavement leave. The qualifying family member is the same as the definition in CFRA. In California, there is no limit. You can take 5 days for every family member who dies. So spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. You can take 5 days for each of them. So if you unfortunately have a large number of family members who are meeting an untimely end, your employee, they're going to be taking a lot of leave. It can be intermittent, but it must be completed within 3 months of the death. In California, the employer can ask for documentation of the death. If you have an existing bereavement leave policy, you follow that, but you need to give the full 5 days. So if your existing bereavement leave policy is the employee gets 3 paid days, for example, you have to tack on 2 unpaid days to that 3 paid days to get the full 5. You could tack on 2 paid days to get 5 paid days, just they need to get the full 5. But you don't have to pay them for 2 if those aren't under your policy. Illinois' Family Bereavement Leave Act, it used to be only for the child. Now it's for child, stepchild, spouse, domestic partner, sibling, parent, parent-in-law, grandchild, grandparent, or step-parent. It's the same as FMLA eligibility as far as years and hours, and it can't be used to go beyond the 12 weeks of FMLA. It can be used for a miscarriage, a failed intrauterine insemination, embryo transfer, IVF, a failed adoption because someone backs out, a surrogate agreement, fails a diagnosis of a condition that affects pregnancy or fertility. You can ask for documentation. If it's a pregnancy or adoption reason, you cannot ask for the reason. Illinois is different. If 2 or more people die, you get a total of up to 6 weeks in a 12-month period. So a little different there. Natural hair and hairstyle discrimination. This is not a new one, depending on where you are located, but it is new in Miami Beach, Florida, and in Illinois. If you do not know about what is commonly called the Crown Act, the Create a Respectful and Open World for Natural Hair Act. This is a movement started in response to employers prohibiting hairstyles such as braids or locks that are more commonly worn by Black employees, or requiring Black employees to chemically process or relax their hair to abide by the dress code. These are things that would have never been required of a white employee. Using hair as a way to treat Black employees differently and then claiming a valid business reason that their hair is unkempt or unsanitary is discrimination, and many states and cities are passing laws to specifically call this out as discrimination. These are just two jurisdictions to get on board on January 1st, 2023. If there is not already a law like this in your city and state, it is likely that your city and state or states will be next. It's best to just ask yourself now, am I doing this? Have I done this? Tell yourself it's wrong and stop doing it. Stop discriminating based on a hairstyle or a hair type that is generally associated with a certain race or national origin, and stop discriminating based on hair. This is, if it's not in your jurisdiction yet, it will be. Maine vacation payout. So why would you want to think of this if you are not in Maine? Well, 9 states currently require payout of accrued but unused vacation upon separation of employment. For any reason, no matter how much you have accrued, if you separate from employment, whatever is in your vacation or PTO bank is paid out to the employee upon separation. So that's currently in 9 states. That is required no matter what the reason for the separation, no matter what kind of policy the employer tries to make. And Maine is joining these states on January 1st of 2023. Maine, it applies to employers with 10 or more employees. There are exceptions for CBAs. If you are a union shop, that is true in some of the states requiring the payout. But this is, and this some states that will surprise you. Usually we see kind of employee-friendly trends start in the larger, more populous states or on the coastal states and start spreading across the country. But these 9 states include Kentucky and Louisiana. So that might surprise you that such an employee-friendly statute exists in those areas. But this is just the kind of Maine joining these states on January 1st is a harbinger of vacation payouts to come. Now, many states require employers to actually have a written forfeiture policy or clause restricting payout if you provide vacation or PTO. So without an affirmative statement saying we don't pay out accrued but unused vacation, you're going to be required to pay it out, meaning if you don't have a handbook or if your handbook is silent on this issue, you owe it and maybe you don't know it. And unless you update this quickly in a handbook or a written policy, you are going to get a savvy employee or an employee with an attorney at the barbecue, and they are going to make a wage claim against you for unpaid vacation. So if you are not in a mandatory payout state like Maine and these other 9 states where you have no choice but to pay it out, if you're not in one of those states and you're thinking, I don't want to pay out anybody's unused PTO or vacation, you're going to have to put a statement in your handbook saying accrued but unused vacation and PTO is not paid out upon separation, bottom line. You need that in your handbook. That's we'll talk about handbooks in a little bit here, but that's something you need to have. So moving on to paid family and medical leave, Colorado. This is similar. We've got 2 paid family and medical leave acts starting on January 1st, 2023. Or employer and employee contributions are beginning on January 1st, 2023, and benefits actually being paid out later. But in Colorado, this paid family and medical leave can be used for some of the reasons under FMLA, as well as addressing safety needs related to domestic or sexual violence. Employees are entitled to 12 weeks of paid leave and 4 weeks additional if there are complications related to pregnancy or childbirth. This is not the same as FMLA. This is paid family leave. So this is eligible at an employer of any size. So unlike FMLA, there is no headcount threshold. This applies to employers of any size. In order to qualify, an employee only needs wages of $2,500 in the state over a period of year. So it's not, there is no tenure and hours requirement like FMLA. Once the employee has been at the employer for at least 180 days, the leave is job protected. If the employee has been with you a shorter time than that, you do have to pay. The paid family and medical leave does get paid out to the employee. This is an insurance policy run by the state that you contribute to. So the state's paying out the employee. And if the employee's been with you longer than 180 days, it's job protected. Just like FMLA, you can't terminate or replace them. If they've been with you less than 180 days, even though they're getting this paid out by the state, you can terminate them. In Colorado, the employer-employee contributions are 50-50. So the total contribution being made to paid family and medical leave is split 50-50 between employee and employer. Paid family and medical leave in Colorado does allow for intermittent use. You can take it a day at a time, not just continuously. So next we have paid family and medical leave in Oregon, and employer and employee contributions to paid leave Oregon also begin on January 1st, 2023, and benefits start later in the year. This can be used for the same reasons as Colorado's paid family and medical leave without the military deployment reason. This also gives 12 weeks of paid leave instead of 4 weeks of complications related to pregnancy and childbirth. Oregon only gives 2. It is not the same as FMLA. There is no employee headcount threshold. In Oregon, you only need wages of $1,000 in the state over a period of a year. The leave is job protected once the employee has been with the employer for 90 days. So a little bit more employee friendly in Oregon as far as qualifying and the leave being job protected. Again, you can take it by the week or a single day at a time like Colorado. And the difference in the main difference in paid family and medical leave Oregon is employers with 25 or fewer employees don't pay an employer portion. So employers with 25 or fewer employees aren't paying in. They're not paying a contribution. They're not making a payment. They can make their contribution. There is a grant they can apply for to pay back their contribution if they do make it voluntarily. Employees of employers of any size make their contribution. So employees, no matter what, make a contribution. Small employers do not have to make a contribution to paid leave Oregon. If it is an employer with more than 25 employees, the split is 60% employee, 40% employer. So slightly different between paid leave, paid family and medical leave, Colorado, and paid family and medical leave, Oregon. But as I said, there are other paid family and medical leave laws in the US. They have started, as I said, on the coast in those some of those more populous and coastal states. And you can see now they've spread to, there's a law in Washington, they've spread now to Colorado and Oregon, which are more employee-friendly states. But as they spread inland and to slightly more conservative states overall, it's on the horizon for you. Paid family and medical leave is something that is coming to the states where you operate a paid leave insurance program run by the state is probably coming up soon in your state of operation. The New York City Artificial Intelligence Law. Obviously, this is not one that affects a ton of our clients, but it's such an interesting one that we've been getting questions from it, even from clients that do not operate in New York City. So we have a lot of clients in staffing that use AI tools to sort candidates. And the idea that laws like this could spread could be concerning. So an automated employment decision tool is a computational process used to assist or replace making discretionary employment decisions. So an AEDT uses data or statistical analysis or scoring tests. So simplifying the output of sorting through a group of candidates and giving a simplified output, or automatically weighing one set of criteria higher than another, modifying conclusions derived from other factors, including human decision making. So employees take a test that the test is supposed to predict honesty, and you're using this to filter out through your candidates to see who is more honest, and you're going to this is going to override human decision making, even if you talk to candidates and you like them. If this decision making tool spits out the list of honest employees based on the test, you're going to go with them over what you think in the interview. That's an AEDT. That would be use of an AEDT. So the artificial intelligence law is saying that a company cannot use an AEDT unless it has been the subject of a bias audit. Now, the proposed requirements for a bias audit include calculating the selection rate and the impact ratio for each EEO1 category on an employer's EEO Commission Employer Information Report: race, ethnicity, and sex. The selection rate is the rate at which individuals in a category are either selected to move forward in the hiring process or assigned a classification by the AEDT, as compared to the total of number of individuals in the category who either applied for the position or were considered for a promotion. The impact ratio is defined as either the selection rate for a category divided by the selection rate of the most selected category, or the average score of all individuals in a category divided by the average score of individuals in the highest scoring category. It's a little confusing, but basically it's kind of dividing to see the impact, who is being selected, divided by who is the total of individuals taking the test or submitting to the automated decision-making tool. Proposed definition for independent auditor: a person or group not involved in using or developing the tool. The results of the bias audit would have to be clearly posted on the careers or hiring area of the company website The selection and impact ratio of all categories would have to be posted on your website. Employers must provide at least 10 days advance notice to individuals who reside in New York City that they use the AEDT, and give them the opportunity to request an alternative selection process or an accommodation. Let them know the job qualifications and characteristics that the AEDT will use, and the type and source of data that is collected. So you have to, you get people who reside in New York City to apply, and you have to explain all of this to them and let them request an alternative selection process. So this is all information we learned in Sociology and Psychology 101. Tests can be biased. If people of one sex or race or national origin are raised in a way that reinforces certain traits or values, when your AI tests yes or no on traits or values or predicts behavior based on reporting of previous behavior, one sex or race or national origin is going to come out on top percentage-wise. And it's not because some people are good for the job or some people aren't. It's because the test is biased. So what this law is trying to do is eliminate that bias from automated screening tools or tests that employers use. And like I said, staffing uses this a lot to whittle down the pool. And this is the first law of its kind, but I wouldn't expect it to be the last. And I would not be surprised to see this maybe in California next, and followed by maybe Washington or Massachusetts, New Jersey, DC, maybe a little bit later. But I think this is something that will catch on, which is why there's so much buzz about it. Form I-9 changes. The current form expired on October 31st. USCIS is extending the current version until further notice. There are proposed changes to the physical form itself. They're in addition to condensing sections 1 and 2, creating some supplements. They're considering condensing the instructions from 15 pages to 7 pages. Keep checking on this. They're going to publish the new Form I-9 as soon as it becomes available, which should be in the next few months. Right now, the remote document inspection is extended to July 31st, 2023. They have proposed changes, including extending that remote document inspection indefinitely, but we will see how DHS comes out on that. Right now, this is one to watch, and nothing has been decided yet. But this is a good one to ask questions of your HR and employment law attorney. You can put questions in the portal. Hey, have you heard anything about Form I-9? We'll let you know. Otherwise, if you are not a client, please check out our packages. This is something that we are skilled at, is keeping you updated on things like the Form I-9. Oregon non-disclosure agreements. Again, this is something in one state that is going to spread like wildfire across other states. This is just a template that is going to catch on and be adopted and proposed in all state legislatures and be passed into law. If you don't like this, this is the chance to jump on the lobbying train. So the law previously barred non-disparagement and no rehire provisions in separation agreements unless the employee asked for it. The law about non-disclosure agreements has now been amended to offer even more employee protection. So if the employee is not represented, the employer must provide model policies and procedures that are drafted by the Department of Labor. This doesn't apply when there's no conduct defined as discrimination under the law. So this is only in a discrimination or harassment case. Washington also has a statute like this. They ban non-disclosure agreements related to all forms of workplace discrimination, as well as wage and hour violations and any conduct that is recognized as against a clear mandate of public policy, which is pretty vague and can involve a lot of wrongdoing that a judge decides occurred on your part. This act is in Washington prohibits applicants, employees, independent contractors from openly discussing conduct that it was reasonably believed was illegal discrimination, harassment, retaliation, a wage and hour violation, sexual assault. This is retroactive to employment agreements, not settlements. Maine just enacted a similar statute in May 2022 that prohibits employers from requiring non-disclosure agreements including settlement agreements in harassment situations. So a no confidentiality provision in a separation agreement would be upheld if the reason for the separation agreement is discrimination or harassment. So those are 3 states with non-disclosure agreements, separation agreements when there is any discrimination, harassment, wage and hour. Public policy means, like I said, anything that a judge thinks that you did that was very bad, you're not going to be able to put an NDA in that separation agreement or that settlement. So we've got 3 states on board, and there should be more to come. Non-compete law, Washington, as of January 1st, 2023, Washington has adjusted their enforceability threshold for non-competes to account for inflation. So the enforceability threshold, the number of money that an employee has to make in order for a non-compete agreement to be valid in Washington has just gone up. So you cannot have someone making under, I believe it's $151,000 a year now, sign a non-compete agreement. It's not going to be valid. This comes on the heels of 5 state laws restricting employers' use of non-compete agreements, and it proceeds pending legislation in 4 states and in Congress. So there was a law in Illinois that was recently passed that did also impose earning thresholds, and Nevada, their amended non-compete bans non-compete agreements with hourly wage employees. Same Oregon employers can not enforce post-employment non-competes against employees who are not exempt employees. Washington, D.C. bans non-competes for employment based on non-compete agreements for employees who make less than $150,000. The D.C. Act also bans prohibitions on working for other employers or moonlighting during your employment, except under certain conditions. So in DC, you can't have a non-compete for someone who makes less than $150,000, and you also can't tell your employees that they can't work at another job. New York, Connecticut, Oklahoma, West Virginia also have pending legislation on non-competes. President Biden has issued an executive order asking the FTC to restrict non-competes at the federal level, and there also are 2 bills that have been introduced at the federal level looking to restrict the use of non-competes. So this is a very hot topic right now. Again, if this is important to you, take this to your legislature. This is something you want to be informed about at the legislative level in your state, and engage in some lobbying or some organizations with some trade groups if non-competes are something that you use with your employees and you feel strongly about. The Employee Retention Tax Credit. Have you filed refundable tax credits to employers for employee wages paid in 2020 and 2021? Talking up to $5,000 per employee per quarter for wages paid in 2020, and up to $7,000 per employee per quarter for wages paid in 2021. This is a refundable tax credit from the IRS. This is essentially, I don't want to say free money, but I don't know how else to garner your interest in the ERC. We can move on to the next slide. I'll tell you a little more about it. So this started with the CARES Act, the first COVID legislation in 2020. It has been amended multiple times by different laws. You may have been told by your CPA or payroll provider that you don't qualify. They may be going by the old rules. They may not be up to date. That is a very tiny sliver of the ERTC. Many businesses who never believed they would be eligible are getting 6 to 7 figure payouts on the ERTC. Even if you got a PPP loan, you're eligible. You can't double dip on those wages, but you can still get a credit for wages that were not paid with PPP funds. Startups, businesses that started engaging in trade after February 2020 may qualify even if they don't meet the 2 tests on this slide here: business operations being fully or partially suspended, or gross receipts in 20 or 2021 decreasing a significant amount. So how do we claim the ERTC? We'll look at the next slide here. Like I said, we've had dozens of clients who were told they didn't qualify. We got 6 and 7 figure refunds. All employers either have their wage reports, which is who made what, for several quarters. They all have them if they do payroll in-house, or they can get the report in a second from a payroll provider. We file all forms. All we need is just a signature from you. If you receive a refund, we bill 15% of the gross amount. If you don't receive a refund, you risk nothing. We charge nothing for determining whether you qualify. Act fast. We have heard that the IRS may run out of money and not be able to pay out, even if you do qualify. If you're not sure, ask us. It's no risk. Just email info@myHRcounsel.com. This is a reason to subscribe to our Ask HR package. This is going to pay for itself. I can't even tell you how many times over. Don't miss out on a huge tax credit going into 2023. This is something I just can't stress enough, and I kind of feel bad that I left this to the end of the presentation. I probably should have led off with this. Employee handbooks. I like to talk about this going into the next year. If you subscribe to Ask HR, our best practices state and federal law compliant handbook is included with your subscription. If you have Ask HR Lite or you are not a client, you can probably get a year's subscription of Ask HR for less than what you would pay a large law firm to draft a new employee handbook from scratch. They would take 6 months to do it. They would not respond to your emails, calls, or input in a timely way. This is the way to get the superior product, everything you need, nothing you don't. It's going to protect you, cover your bases, communicate clearly with your employees, get you into compliance, and it's going to be backed by employment law attorneys. You need an experienced HR employment law attorney. Handbooks can be found on the internet, are not specific to your industry, your state, your headcount. Handbooks from HR advisors or related services come with a disclaimer stamped on the handbook. For more information about handbooks, open a ticket or email info@myHRcounsel.com. Like I said, starting 2023 with an outdated handbook is getting out on a bad foot. Compliance with some of the other things we talked about today aren't going to matter if you have an outdated handbook. So everything we went through up until now, if you've got an outdated handbook, you just wasted your time, because those things aren't going to matter if your handbook is out of date or unwieldy or has, too much information you don't need, or isn't covering some of the important things that should be covered in every handbook. So for our final notes, ask questions. If you hear a rumor, if you see something in a blog or on the news or word of mouth or on Twitter, open a ticket. No question is too big or too small. We are attorneys. We know how to find the law. We know how to read the law. We know how to interpret the law so that you can understand how it affects you and what you need to do to comply. When in doubt, find out. You want to be in compliance, and you want to be up to date. Things like privacy law, paid family and medical leave, mandatory vacation payout. These, like I said, these start on the coast, they start in more populous states, and they gain attention from legislators in other states. If you want to avoid something like mandatory vacation payout or other things in your state that you feel would be burdensome on you as a small business or a medium-sized business, follow your local legislature or assembly and lobby and organize. Between the ERTC refunds, employee handbooks, you get the no disclaimer, unlimited legal advice, legal documents such as confidentiality agreements, offer letters, separation agreements, hybrid and remote work policies. The best thing you can do to kick off 2023 with Ask HR and our other packages available at myHRcounsel.com. We'll make sure you have a happy new year from an HR and employment law perspective. Like I said, if you have any questions and you are a client, please open a ticket. If you are not a current client and anything I've said here today has sparked a fire to start 2023 off right, please go to myHRcounsel.com or send us an email at info@myHRcounsel.com. We want you to have a happy new year, and we're here to help you do that. So thank you all of you for participating in the webinar today. It was great to share this with so many of you. And I hope everyone has a great holiday season and a happy new year.